Thank you, Mr. Chairman. I appreciate just hearing from both sides here today. It at least can inform us that there are reasons to consider the possibility that there may be some problems with the treaty. A treaty assumes that others will follow the rules and that there's an enforcement authority that will act forcefully and quickly and fairly. I think in this time, with our experience with international bodies, that this is terribly naive. And to suggest this creates a predictable framework for us to operate in as a nation concerns me deeply. I mean, our experience with the United Nations and the WTO, and we see the world courts and other international bodies, there's absolutely no indication that there will be predictability and that the signatories to these agreements are actually going to follow the resolutions of the authority. We can look at the signatories to the Law of the Sea Treaty and look at their voting record with us in the United Nations. Well over 90% have voted against the United States over half of the time. And as I look at the language, this idea that the United States has a veto vote is not carried out by the facts of the agreement. We don't have an individual veto vote by what's in the language. And to suggest that we can stop things and conform things with a veto, the language appears to say that the individual chambers can veto if they have 2/3 vote. And we will be in a chamber with China, Italy, Japan, and Russia, all of whom have voted with us less than 50% of the time, and some down at the 20% level. And we have to get 2/3 of that council in order for there to be a veto. Now, if I'm wrong technically, obviously I'd like to hear it. Reagan's name is used often in this, and if you read what his ambassador, Jim Malone, has said, even after '94, he did not think this agreement was fixed. And Reagan had an approach that I think we need to think about today. He supported the treaty and tried to comply with it, but he did not submit our country to it. In other words, we left room to act in our own best interest. Clinton, in his letter of submission, when he submitted the document here, or the whole agreement, he saw it as a far-reaching environmental accord addressing vessel source pollution, pollution from seabed activities, ocean dumping, and land-based sources of marine pollution. So it seems like everyone we hear from is telling us something a little different. Our military is saying this is vital to military interest, that it has something to do with the ownership of seabed properties. It also is a major environmental treaty, and there's vague language in all of these areas as it's not complete. And just my one question to this, and I'll just direct it to you, Admiral, because the testimony does appear to say that while there's no current problem, there could be a problem in the future. But we've been operating under customary law for a long time. How is the United States military currently encumbered by not being a party to this treaty?
I think that the answer to that is that we have embraced the principles. The Commander-in-Chief, when President Reagan said we were going to operate in accordance with the principles that were related to national security, we absolutely embraced those principles. The manner in which we are impacted today are in areas, for example, the Proliferation Security Initiative is a very important vehicle that is aiding us in the execution of the global war on terrorism. When you talk to our commanders today, and I've been retired 2 years, but I spoke to people that were part of this as late as last night, I am hearing from senior commanders that our non-participation in this convention are causing people, other countries today, not to become part of PSI. because it is a public proclamation that we do not want to be part of the community of nations that are that have defined rights that are important to us. Let me emphasize that the most important, and I have called it the crown jewel of rights that I believe that we need to nail down, is this idea of transit passage. It did, when in my earlier testimony, I said I was there when we didn't have these rights, so that every time that we pass through an archipelagic situation or a strait, the issue was on the table about what particular range, this particular excessive range claims, territorial claims that a particular nation is making.
We not have those rights now, right?
What I'm suggesting is that it is the view of the United States military, and that's why you've got the Joint Chiefs of Staff and the United States Coast Guard and all the parties that have spoken up in support of this, is that it is important for us to proclaim our support for this set of standards and rights that are essential for us to avoid a confrontation every time we pass within a particular range.
Is it your belief that Iran and other signatories will follow the directive of the Law of the Sea Treaty?
I'm not responsible for what position Iran decides to take.
But they are a signatory to this treaty. Your suggestion is
that
we will submit to a treaty, assuming that all the other countries will submit to it as well, so that we will have a predictable courses that we can follow without interrupting. And you are assuming that our enemies are going to do the same.
Well, what I would suggest to you this morning is that we would certainly hope that they would honor the rights that they've signed up to. Senator, if they don't, believe me, we know what to do.
Senator, may I take a minute to respond? I'm very concerned about the Proliferation Security Initiative, too. I agree with Admiral Clark that it is very important. I think all of us believe it's a very important tool. Were we to be party to this treaty, there are exactly 4 circumstances under which we could engage in the interception and boarding of ships. That is not the case today. We have the right to do that where we think that the need exists, and we have currently, happily, still got the naval power to do it. But under this treaty, unless a vessel is engaged in drug trafficking, piracy, offshore broadcasting, or slave trafficking, we cannot intercept that ship. And I submit to you that we shouldn't be hamstringing this Proliferation Security Initiative, and it is going to be hamstrung, I think. And to the question that the Admiral pointed out about what importance this has for our services, I understand the importance they attach to these navigation rights. I also believe that part of what is animating them is a concern that these navigation rights are going to be mutated in the future. The problem is our participation in the treaty is not going to prevent that from happening. The seat at the table is, as my colleague has pointed out, not going to give us a veto over those kinds of changes, and I think that they will work to our disadvantage because we'll be bound to honor them.
Well, thank you. I'm over time, and thank you for indulging us, Chairman.
Mr. Oxman, I see you look pained. You want to briefly, since everybody seems to be buying their own time here in the process, would you like to...
Thank you, Mr. Chairman. Very, very quickly, Senator DeMint, and I think totally correctly, because the way in which these provisions are organized makes them almost opaque, raised the point that he didn't see the reference to veto, which would flow from a consensus decision-making system, and I just wanted to point out that it can be found in Article 161, 8D, which in effect gives us a veto when we take our seat over the adoption of amendments and over the adoption of regulations. The other is on the Proliferation Security Initiative. What Mr. Gaffney is complaining about is the limitations on boarding that are contained in the existing Convention on the High Seas that the United States is a party to. The new Law of the Sea Convention gives us greater rights to board than we have under the existing treaty to which we are a party. The new Law of the Sea Convention, I come from Florida, gives us greater rights to rescue our citizens who may get into trouble in the Cuban territorial sea than we have under the existing territorial sea convention to which we are a party. So that, in fact, we are in a stronger position under PSI if we adopt the new convention than if we stick with the existing treaties that are the law of the land.